G'day everyone, and welcome to the second video in week 6 of our admin law course. This week we're looking mostly at the grounds of review, which we describe as the narrow ultra vires rules, which really means these are the rules where we test whether the decision maker had the power to make the decision that they made. In the first video we asked if there was an enactment that gave them the power, and we asked whether all of the procedures had been followed that were necessary for a decision to be made at all. In this video, we're going to focus on the person. Section 5(1)(c) of the ADJR Act says that a decision can be reviewed if the person who purported to make the decision did not have jurisdiction to make the decision. At a basic level, this is pretty simple. There are lots of public servants who work in lots of different areas and who have lots of different ranks and grades. When the Parliament establishes an administrative power, that doesn't mean any old public servant can make the decision. If you want approval to open a new airport, you don't go and ask someone from the Education Department. Similarly, if you want a multi-million-dollar grant, your decision maker is not going to be the person who sits at the reception desk. That's not to denigrate the person at the reception desk either. It just means that different roles have different responsibilities, and so each decision must be made by the right person. How would you expect the right person to be designated? We'd expect it to be in the statute, wouldn't you? And so it is. Let's go back to the learner-driver logbook example we've been using this week. Regulation 32, Subregulation 1 says a young driver may apply to the Chief Executive for approval of the young driver's logbook. Then Subregulation 3 begins, the Chief Executive may approve the logbook. So who has the power? The Chief Executive has the power. Simples. But this is law school. We can't let things be simple. Let's complicate it. We start with ministers. We first talked about ministers in the first week of the course in the video on the separation of powers. Ministers are elected members of Parliament who have responsibility for particular areas of policy. So you have an education minister, a health minister, a defence minister, and so on. Often, legislation gives decision-making power to the minister. Realistically, no minister is ever going to have the time to make all those decisions, and every minister has their very own public service department to help them. And so there's this concept called the alter ego doctrine. This means that whenever the legislation gives a decision-making power to the minister, that decision-making power automatically transfers to the Chief Executive of the Public Service Department. The authority for the alter ego rule is a case called Carltona and the Commissioner of Works, which was a case about the wartime requisition of a factory. It was challenged partly on the basis that the minister had not personally made the decision. That challenge was unsuccessful. There are a few exceptions to the alter ego doctrine, but they're pretty few and far between. We don't need to worry about them here. The second complication is the concept of delegation. Again, let's consider the driver licence logbook situation. We've established that the power to approve a logbook is given to the Chief Executive of the department. Now, there are about 60,000 17-year-olds in Queensland according to the census. Even if their applications were all spaced out nicely, if every 17-year-old put in their logbook, that would mean the Chief Executive would have to review 164 logbooks every day, 365 days a year. That would mean, given an 8-hour workday, one every 3 minutes, 7 days a week. They wouldn't have time to do anything else. And so even though the power is given to the Chief Executive, it gets delegated to people who work for the Chief Executive. Now hang on, I hear you say, that defeats the point. If the Parliament gives the power to the Chief Executive, but the Chief Executive can just give the power away, doesn't that defeat the intention of the Parliament? Well, that's a good point. But what if the Parliament specifically gave the Chief Executive permission to do that? See, the Transport Planning and Coordination Act contains a section called Section 37, which says in part, the minister or the chief executive may delegate to a person a function or power under this or another act. And then section 123 capital D of the Transport Operations Road Use Management Act 1995, which is the legislation that our logbook regulation is made under, that says that section 37 applies. So the Parliament has specifically made a rule allowing the chief executive to delegate this power. There are hundreds of these delegations under hundreds of pieces of legislation. Each department has to report to the Parliament and make publicly available its lists of delegations. So when a delegation is made, it's made publicly. The authority for all this is a case called Proudfoot and HREOC, the Human Rights and Equal Opportunity Commission. I think Proudfoot was the surname of a family of hobbits in The Lord of the Rings, but I'm going to assume this was just a coincidence. In Proudfoot and HREOC, the applicant was cranky because a women's health service in the ACT did not also provide a men's health service. And he challenged the decision to provide the women's health service on the basis that the chief executive did not personally make the decision. The court found, fairly obviously, that there was a valid delegation and the decision need not be made personally. There's only one other thing we need to talk about here, and that's what we call the rule against subdelegation. Let's say the chief executive delegates the review of logbooks to a new type of officer called a logbook inspector. Now let's say that in, Charters Towers, there was a logbook inspector who didn't like work very much, and they decided to call one of their staff an assistant logbook inspector and get that person to do all the work. Can you see the problem? The person making the decision there is not the person specified in the legislation, and they're also not a person nominated in a formal delegation made under the Act. A person who has received a delegation must make the decision themselves. They can't delegate it further away. This is the rule against subdelegation. So, where does all of this leave us? We have this idea of narrow ultra vires. Narrow ultra vires is all about whether a decision maker has the right to make a decision at all. We know that they don't have the right to make a decision unless they can point to an enactment which requires or allows the decision to be made. We know that sometimes the enactment will require certain things to be done before the decision-making power springs into existence. And if those things are not done, then there's no decision-making power. Finally, we know that the decision can only be made by a person nominated by the Parliament. However, if that person is the minister, then the alter ego doctrine means they can pass the decision to their department, and in any event, the legislation might allow for decisions to be delegated. If a person receives their decision-making power from a delegation and not directly from the enactment, they can't subdelegate the power any further. Now that's pretty much all we need to know about narrow ultra vires. In the third video this week, I'm going to talk about a concept called jurisdictional error of law, which is closely related to narrow ultra vires. Jurisdictional error of law is actually a really important concept, even though as an undergraduate, it just about did my head in. Let's give it a crack.